SJC-13213, Commonwealth v. Kyle S. Dawson.
Okay, Attorney Renaud.
Your Honor. May it please the Court, Suzanne Renaud for Kyle Dawson. Your Honors, this case comes down to whether or not a case that was decided in 1863 is still good law. And it's Mr. Dawson.
Can I disagree with you for a minute or push on that a little
Sure.
bit?
Yes,
Does
Your
it
Honor.
really come down to that, or do we actually look at our current statute of involuntary manslaughter and all the cases on it that have come since, and say there's a theory where you can have it based off the felony, or you can look at it through a wanton and reckless analysis? Why aren't they two separate things?
Well, Your Honor, I'm going to, I think that what you're focusing on is perhaps the argument that the amicus made regarding Walensky. I don't think that my sister made specifically that argument regarding Walensky. But what I would say is this, is that number one, reckless manslaughter was very well known at the time Walensky was decided. In 1888, Pierce was decided, which was cited authoritatively in Walensky. Pierce cited to sections of Lord Hale, which I also cited to, and also to the 1802 case of Commonwealth versus Thompson, which was a case where there was a discussion of wanton negligence or recklessness, and it determined only that it wouldn't apply as a basis for manslaughter because it wasn't a criminal act. And the thing that Pierce changed was it said that non-criminal acts can also be the basis of recklessness. However, Walensky did not actually represent a sea change in the idea that reckless manslaughter existed. Even Commonwealth versus Webster reflected that. And so when we have to have that starting point, perhaps obviously Walensky clarified what the scope of or how we're going to specifically define reckless manslaughter, but it didn't actually change manslaughter as a sea change. In addition, Your Honor.
On that, counsel, but that doesn't mean it didn't exist at the time that Campbell was decided.
Well, but if the understanding of manslaughter at the time Campbell was decided is akin to the understanding of it after Walensky was decided, and the court in Campbell very definitively said, this is not felony murder, and if it is a shot that's fired by somebody other than the defendant, a confederate, or somebody working on the same side of criminality, somebody who's resisting or opposing or thwarting in their language, then it's also not manslaughter. And that was the understanding that was reflected by the Attorney General. That's the understanding that was
decided on the basis of the agency relationship, wasn't it?
You know, Your Honor, I'm going to just push back a little bit on the discussion of calling this an agency relationship. That's not the term that Campbell used. That's the term that other people have used afterwards. And it's made clear that we're not actually talking about traditional agency. We're talking about, sure, it could be an accomplice or a joint venturer or a confederate, but it could also be somebody who's engaged in the same criminality, such as the rioters in the duelers in Philadelphia, which Campbell cited to, which was also something that came up.
Isn't it vicarious liability?
I'm sorry?
Isn't it vicarious liability?
Well, that becomes a vicarious liability issue, and whether or not there's actually control. I mean, if you look to Handwright, is there control? Is there knowledge? Is there some kind of connection? Is this the intended end?
Well, wait, where does that come in? In a manslaughter charge on recklessness, it's the act that's intended, not the outcome, isn't it?
Mm-hmm.
The act has to be intended, Your Honor, but when you're even talking about a joint venturer, if you do not have an idea of how that joint venturer is going to behave, then you're not responsible for that person's actions. And that is why that hard cutoff was made in Campbell. And Campbell very clearly says, look, when we're dealing with this idea of some kind of serious homicide crime, any kind of homicide crime, and they were very clearly talking about manslaughter and the idea that somebody could be acting recklessly by engaging in a riot, and potentially that would expose them to murder or manslaughter. And they said in neither case, and this was a comprehensive categorical holding. In neither case.
Let me press you on that, because you raise a really interesting issue, and it's very well briefed. But you recognize, of course, that as you've charted it out, our law of homicide is the common law, which evolves.
Yes, Your Honor.
And the biggest problem you've got is the language in Tejada that exempts this. So why don't we look at this issue? We start at Campbell and Pierce et al., and we go from the Civil War to the, I guess, World War II, right? And then we go to Bolero.
Yes.
And we make this journey through our common law, and we end up, the last we spoke, with Tejada.
Yes.
In this
But-
evolution of the common law, don't we stop at Tejada and say, I'm sorry, you're wrong, because in Tejada, Chief Justice Gantz, then Chief Justice Gantz said, well, don't worry, all you people, you still get your manslaughter.
Your Honor, he didn't do that, though. What he did, if anything, in that dicta, which was very clearly dicta, which was addressing a very specific question about what happens if a bystander dies. And he said, in essence, without giving any examples from any cases, didn't cite to, say, Taylor from California or anything else, didn't even say the facts of Tejada or the facts that approached Mr. Etienne had anything to do with that particular exception. And incidentally, the fact pattern in Tejada is very similar to the fact pattern with Mr. Dawson.
I know.
But he didn't say, well, this exception that I'm talking about would apply to the facts that are before me. What he said is, if there was a bystander, there might be, under certain circumstances, some kind of situation. And then that last sentence of that paragraph basically implied, no, it didn't come right out and say it, and again, you have to read all of this in the favor of the defendant.
And please help me out. How is a bystander different than a Confederate?
Well, I would say they're not, and that's what Bolero said, but yet Chief
Right,
Justice
that's
Gantz
the
made a
point.
distinction.
And that's the point. So
And-
why? So again, so I go back to the language in Tejada that gives this option, and I don't see the difference, because we have an unintended person, right, who's dead.
Well, Your Honor, the problem here has to do with clarity. It has to do with due process, and it has to do with fairness to somebody in 2018. I think even the Commonwealth, I mean, to not put too many words in the Commonwealth's mouth, in the application for DAR on page 16 said, if you want to change the law, you have to say it expressly. And what that that section 3, which was very clearly dicta, did not say the facts of Tejada would in any way be subject to whatever potential situation that was being described.
Let's go back a step and look at our manslaughter law in general. We've had plenty of cases since Campbell, obviously, and Tejada, and we have a law of manslaughter that's simply based on wanton and reckless conduct. That's not gone. Do you agree with that?
That's true, Your Honor, and it's always been that way.
Right, it has. So how does your case get outside of that line?
Because, Your Honor, what Campbell did from the very get-go was basically said the actus reus, the act, the bad act, not the causation, not the intention. The act of homicide is simply not going to include the acts of somebody who's resisting, opposing, or thwarting the crime. And it said that categorically. And I think it doesn't matter.
Campbell was felony murder, right?
I'm sorry?
Campbell was felony murder.
It was both, Your Honor. It was being addressed as both. It addressed it as both, Your Honor.
It addressed it, but that wasn't that misdemeanor manslaughter?
It was not, Your Honor. It was not, Your Honor. First of all, misdemeanor manslaughter was not understood at the time. Secondly, it was very clear that rioting was considered to be a felony. Otherwise, we wouldn't be talking about this as felony murder.
They never, I mean, Campbell never uses the word felony murder.
It doesn't, but this court in Commonwealth versus Brown recognized.
That's a point for you, so I don't know if you want,
Okay.
I don't know if you want to start your sentence by but.
Well, no, I'm agreeing with you that Commonwealth versus Brown confirmed that it was in fact felony murder. But what it did in that last paragraph in Campbell is it said that if this was something that was a bullet fired by the rioter, it will be felony murder. If it was fired by somebody else, it is going to be neither. The court was actively considering whether this very idea that you're expressing, that kind of reckless conduct, not intentional but reckless conduct that led to the death of a person, could be manslaughter, and it said no. In addition, there were at least 2 other cases across the country that were manslaughter cases that adopted Campbell and applied it that way. I don't think there was any change, and there have been no fact patterns other than Bolero and Tejada where we're talking about the death being specifically caused by being the result of an act of a person opposing, thwarting, or resisting the crime. There are very few of these cases across the country, and there have been very few published cases in Massachusetts dealing with this. So we're not talking about, whatever change Walensky made, we can't really say that it's had any effect on this because there just haven't been cases that have been testing this.
So the only thing Mr. Dawson could be charged with, in your opinion, was the armed robbery.
Could he be charged with armed
No,
robbery?
the only thing he could be charged with is armed robbery.
Well, yes, Your Honor. I mean, I think,
And isn't that the point that we made in Tejada when we said, you know, you may complain, prosecutors, that you can only charge this person with the felony, but don't worry, there's always a manslaughter option.
and that is, it is not, Your Honor, because, look, you know, there is, at the end of the day, as a policy matter, the courts, or the Commonwealth, and I'm sorry, I don't know if it's statute or if it's common law, has decided that there are excused self-defense killings. Not every killing is criminal. And the killing here was something that was a result of somebody acting in self-defense. Certainly, the bad act, Mr. Dawson, you know, has pled to the armed assault to rob. So he's clearly committed a crime that carried up to 20 years of jail time, of prison time, which could also have the idea that somebody died as a result of that could apply to his sentencing.
But you need to obviously have this under the Bolero-Campbell rubric, because under wanton and reckless conduct, I think in the light most favorable to the Commonwealth, bringing a gun and robbing someone.
Well, it was a knife, Your Honor.
Well, yeah, a deadly weapon and robbing someone clearly leads to violence. That's the whole purpose of the felony murder law.
Well, you could also say that, I mean, you can make the argument that any kind of violent felony is going to carry the risk of death, obviously. I mean, like that's something that is inherent here. You know, it's going to necessarily, that is the conduct that is getting punished. And so I think that there's potentially, this Commonwealth's other argument is that this was a particularly egregious behavior. And I think that there becomes a bit of a slippery slope, because the idea that somebody's going to turn over their property is because of the threat of the dangerous weapon. So I think that you have to take that.
In this particular case, don't you have a bit more in that you have a cab driver, they know that there have been robberies of cab drivers, there have been killings in the area, the guys who robbed it and robbed this cab driver or tried to. So they're very well aware of the heightened risk of what they're doing. It's not just a regular armed robbery.
Well, Your Honor,
And one used a knife and put it to his skin.
putting the merits of that aside, the question has to do with how clear is the Commonwealth's law. When Tejada reiterates the holding of Campbell without limitation, says it applies to all homicides.
Are you saying it's a due process violation?
There certainly is a due process issue here.
Was he, and forgive me for not knowing this off the top of my head, this case comes out after Tejada, right?
Yes, it was 2018, Tejada was 2015.
Okay, so how is there no notice?
There isn't notice, Your Honor, because what did Tejada do? What was clear about Tejada? I think that there was language from Triplett about the level of clarity that has to be in the law. And remember, this is in the defendant, the rule of lenity, essentially. I don't know if it applies in common law, but there are equivalents of that apply in the common law. And the idea here is, what is Tejada actually
No,
saying?
he's entitled to fair notice of criminal conduct.
And my point of the matter is that Tejada absolutely, from the top, restates the whole, if I could just go through this, it restates the holding. It doesn't say that there's any question mark, any footnote, any asterisk about the extent of that holding. And that's the first point. The second is, it didn't say that the facts of Tejada would potentially lead to the idea of manslaughter. It very specifically had a carve-out in dicta that didn't think through these issues the way this court's thinking of them now, relating simply to a bystander. And that was the only thing. The last sentence of that...
The bystander for a minute, that language, because whether we call this man a bystander or a victim, the language in Campbell, or not Campbell, but Tejada says that, doesn't it, that the risk, it says that the court stated that an involuntary manslaughter conviction may be obtained when the defendant committing an underlying felony engaged in reckless conduct that created a high degree of likelihood that substantial harm will result to another person.
Well, Your Honor,
why is that not clear?
it's not clear for the reasons that I'm stating here. And if I could just finish with that paragraph, because what it's saying is it's giving one specific example, not a whole host of examples. It's saying might, it's saying that this could happen, it said it could be in the right circumstances, and then that last sentence in that paragraph says, it says, when a person commits a crime and then has some act, it doesn't say that it has to be an additional act. But what it is basically saying is if, say, the defendant acts in a way that he knowingly puts somebody in risk, like in the case of a human shield. And that is the difference here, is that especially that last sentence then throws things into account. But then the following paragraph, and I think this is really important, repeats the holding of Bolero and says that we agree with the holding of Bolero that there should be no criminal liability in these situations. It doesn't say there should be no murder liability. It doesn't say no felony murder. It says no criminal liability. And that right there puts all of this into question, because no matter what else you are saying, it's saying that there is some language in Tejada, in that dicta, that's clearly dicta, that is limited dicta, that doesn't even have any level of clarity.
So the hold in Tejada is clearly geared towards felony murder.
It is clearly geared for felony murder because that was the issue that was
No liability for felony murder. You have to include that in your summary.
Well, there is no, but Your Honor, when the court then goes back and says, but we readopt Bolero, and Bolero was talking, I mean, I just reread Bolero this morning. It actually looks like the defendants were charged with all theories of murder in Bolero, not just felony murder, but the court chose to only discuss it under felony murder because that was the one that I think that had the most.
That was the error in Bolero was not given the jury instruction, correct?
It was about the jury instruction,
And
but
the judge basically saying if you find the killing happens, they have to be guilty of it.
right, and but I think the point there is that look, this same holding or the same example or footnote 3 that you're discussing in Tejada could potentially apply to the third prong of malice too, but you're not necessarily going that far. I think that.
Let me just assume you're right as it relates to your client.
Yes, Your
You spent a lot of time thinking about this.
I have Your Honor.
And let's just say you're right. Tejada's dicta, Campbell still law, and you have the benefit of that with your client. Nonetheless, the common law evolves,
Yes, Your Honor.
and while it might mean success for your client, we've got all this law on wanton or reckless conduct. All this law, we have a body of law. Are we tied to Campbell? And why isn't it, going back to Justice Cypher's point, putting your client aside, thinking of all the time we put into this, why shouldn't there be wanton or reckless conduct in this situation, assuming the facts would support?
So, Your Honor, I think that the question of why it should be wanton and reckless conduct might be better aimed at the Commonwealth, who wants to find my client guilty, as opposed to me at this point. But if the question is,
Why shouldn't it?
well,
be?
why should Campbell be reaffirmed is maybe the better question. And I think obviously you have a policy choice to make because you get to decide. It's your choice ultimately. I don't think it should be retroactive because I believe that this is a change in the law. But my reasons are multifold about why I think it shouldn't change. Number one, as I pointed out, that the actual killing here was done in self-defense, and that is excused. The defendant should be held responsible for his conduct, which in this case is committing a violent felony. And even if there's some kind of outcome that wasn't intended, and he clearly didn't have any control over, the fact that he doesn't have any control over another person should certainly weigh on this. Those are some of the issues that Campbell ends up bringing up. And I think that the other point that I made earlier about Handwright and how this court is in a minority in how it treats joint venture liability. If you wouldn't necessarily find even a joint venturer responsible when somebody else does something that they had no knowledge of, or control, or desire, or intent for it to happen, why is it fair to do that to a defendant? Now, these are my arguments in favor of retaining Campbell, and you obviously can reject that, but
The answer to your last point, because it's not felony murder, because it is just manslaughter on reckless and wanton conduct, we're not looking at it through that lens?
well, Your Honor, I think that the problem with changing it, and this is ended up being what happened in California, which incidentally did it basically on a third prong of malice, the essential of that, in Taylor, it ends up being an exception that swallows the rule. And what ends up happening is that you end up saying that every single time somebody commits a violent felony and then there's a reaction to it, that person is responsible for the death. And I think that there is a better way to look at this. Now, manslaughter itself is a 20-year felony. Armed assault to murder is, armed assault to rob is a 20-year felony. Actual armed robbery is a life felony. You already have punishments for the actual actions that the defendant is responsible for. And I think that that is the reason why, don't expand the law of manslaughter simply out of some idea of retribution. It's a tragic death, but not every tragic death needs to have a person who's responsible for it criminally. And I think that's really the end result here. And again, it's not that the person isn't going to be responsible for the crime that they actually committed. So that would be my position. I am asking this court to remand and for resentencing. If you have any further questions, I'm happy to answer. But otherwise, I'll just rest on my briefs. Thank you very much, Your Honors.
Thank you. Okay, Attorney Stern.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. To sort of begin in the middle chronologically with regard to what a defendant can and can't be sort of responsible for, in Wolanski, the court addressed, among many other points, that to convict the defendant of manslaughter, the Commonwealth was not required to prove that he caused the fire by some wanton and reckless conduct. Fire in a place of public resort is an ever-present danger. It was enough to prove that death resulted from his wanton and reckless disregard of the safety of patrons in the event of fire from any cause. And, any cause could include sabotage. It could include an act of war. It could include...
Would this apply to every armed robbery then?
Well, I think that there's a couple of responses to that. I argue in my brief that the extent, as with Carrillo, they're somewhat different from Carrillo. There's always a possibility of this happening, but it becomes, in order to reach the high likelihood of substantial, essentially that there has to be a tight nexus, even above and beyond probably.
This was obviously a debate in Brown.
Yes.
About where third-pronged malice begins.
Yes.
And involuntary manslaughter ends, and whether this is basically a feature of any time someone robs someone with a deadly weapon.
And yet, so certainly if you have a deadly weapon in play, and instilling fear, there's always the potential for things to go wrong. One thing I would say is to say that, the conduct is so dangerous that we can't have it be wanton and reckless. I get that you don't want the exception to follow the rule, but that seems like it would be a sort of odd result that, this is too dangerous to fit under that rubric.
So how are limited to bystanders, or does it involve Confederates, the death of a Confederate?
I took it to involve any sort of death that cannot be charged as felony murder but results from the armed robbery. Certainly, I think it at least, in the sense of either putting out there or raising awareness of the fact that involuntary manslaughter might apply here, notwithstanding all of the...
But I think your sister's certainly right that Campbell, and I think Bolero as well, only deal with this vicarious liability issue. I don't remember if Bolero has a discussion of felony murder. Campbell certainly doesn't, right?
Well, I think that a number of things, as I think Chief Justice Gantz pointed out, either in Brown or Tejeda, that agency law wasn't fully developed in Campbell, so they referred to all of these doctrines or many of them were there, and my sister was arguing that malum in se manslaughter wasn't in existence then, that it's dealing with the general scenario, but a lot has evolved and not necessarily been sort of formally superseded in a particular case, but changed with time. That involuntary manslaughter, Wolanski manslaughter has evolved, felony murder has evolved, and it hasn't negated what went before, but that the playing field is not identical to anything that was being talked about. And in terms of, riot law having potentially its own implications in addition to just being a felony. So I think that as I argued that sort of where we've ended up after all of this.
The Tejada discussion is dicta. You agree to that?
Yes, but it is fairly.
It's really good dicta? Is that what you were telling us?
What?
It's good dicta?
It's good dicta, and it's also, it's a policy discussion of where we go from here given the court's ruling. So it's, I guess you could make an argument that the concurrence in Brown abolishing felony murder was dicta, except that it has very strong acting value. It wasn't necessary to the holding in that case, but that is how this court frequently conveys the laws going here from here. It's phrased as might obtain. It certainly doesn't say in any given case you can obtain, but I think it was a strong indication of the availability of this as a potential remedy on the right set of facts. So I think that, yeah, I mean, technically dicta, but powerful dicta, sort of working dicta, if that makes any sense.
Counsel, can I ask you to go back to Campbell for a minute?
Sure.
There's language in there on page 544 and 545, after it discusses how no person can be held guilty of homicide unless the act is either actually or constructively his. And then later it clarifies this and says, the limitation applies to preclude liability. Well, it actually says to any person engaged in opposing and resisting a crime. How do you get around that?
Well, I think that, I mean, as I argue in my brief, I think that where we have ended up with the law of involuntary manslaughter, that would not make sense as still good. That, I mean, when they argue that, well, it would make no sense to hold a defendant liable under XYZ scenario, those don't all read as reasonable to us, I think, as they did then, just because our sense of sort of what you could be on the hook for. I mean, certainly from a perspective of agency, yes, but that I think that looking at it through the lens of our modern law of involuntary manslaughter evolved in cases that didn't happen particularly to do with armed robberies, that those things are foreseeable, and that those are the sort of things that you would expect for wanton and reckless conduct, which is very serious. It's not negligence. It's a different animal, as the court said in Wolanski. That those are things that we now do think that you would foresee and potentially be responsible for, even though you are not formally in cahoots with.
But isn't that different? Because when we talk about what you were responsible for, and as Ms. Renaud points out, with respect to Wolanski's conduct, his conduct wasn't lighting the fire. Of course, it was shutting, locking the doors.
Mm-hmm.
It's the same as the omission in the tragic Worcester fire case, and there's lots of those cases where it's that conduct. But here, I think we're talking more not of conduct in the sense of involuntary manslaughter. We're talking about vicarious liability for the act of another, and that's where Campbell kicks in, as well as Bolero.
Well, I think the question there has to be, is it different when there is another, does the role of another human being in this scenario, even if they're behaving in an entirely predictable way, given what you have goaded them to, mean that you're suddenly in a different universe, where if a person were not involved, everything would essentially fit into place under does the involvement of, again, does the involvement of another person completely negate any chain of causation for this purpose?
You can have wanton or reckless conduct, even if somebody else unexpectedly is killed, no doubt about that. But as it and where we go from here is a very interesting question. But as it relates to this defendant and what the law was at the time, what is the law considering Campbell at the time of trial for there to be a conviction for involuntary manslaughter?
Well, I would say I have a couple points there. One is that, the evolution of the common law essentially is, it's not like with the statute where you say suddenly this is the rule and could you have seen it before? I cited in Carter too, though it did not make it into this court's decision. The Supreme Court has said ex post facto clause does not apply to common law because it evolves. It has to be unexpected and indefensible with regard to previous law, because otherwise, that's how the common law works. It builds incrementally. It doesn't.
I don't know how that is going to work with cognate provisions of the Declaration of Rights.
Yes, well, leaving that aside. But I'm just, the general point being that if something is, that it's not, I mean, charging decision, I think that I would argue that a reasonable person can look at Tejada and be like, and say, this is potentially conduct one could get charged for. That's certainly what we thought. Looking at the same law, I'm not going to claim the Commonwealth is a reasonable person. But in addition to that, the general, I mean, as what this court said in Carter too, that the defendant was on notice that conduct similar to hers resulted in criminal liability. I mean, in this case, it's sort of, for one thing, the defendant's trying to commit a life felony. He does not succeed in committing a life felony.
Carter, you're not running into Campbell. You're not running
No,
into...
that's true, definitely.
Carter, you're sort of dealing with more different application of the same standard to different facts. Here you've got to sort of work out the differences between Campbell and Tejada,
Yeah.
which
I
is a
mean,
little trickier, right, in terms of,
well, it's differently tricky.
yeah.
But I would say that, well, one thing I would say is this is a scenario in which the defendant is choosing to engage, he's engaging in wanton and reckless conduct that could foreseeably, I would argue, kill any of the three of them. If it killed the defendant, obviously we wouldn't be prosecuting him, so some things are automatically ruled out. But to say that a defendant who was engaging in this wanton and reckless conduct would have believed that he would only be on the hook for one out of the two potential people who could die because of this bright line rule, I don't know to what extent there's fundamental.
But I guess the problem I've got is,
Yeah.
earlier question, which probably I'm not resolved in my mind, or you haven't answered, is what's the break? I mean, is it every armed robbery we're going to get involuntary manslaughter if things go sideways?
Well, I mean, so I think if you want a bright line rule, that's felony murder. But in this case, I think that there are probably exceptions.
Yeah, I know.
Yeah, I know. So, there are pros and cons of bright line rules. They can be over-inclusive. They can be under-inclusive. Fact-based analyses can be really annoying. So I think that you could probably have scenarios in which there's an armed robbery in which everyone involved is sort of going through the motions and no one's that scared, where you would not necessarily expect. There's always a possibility someone could die, but you wouldn't see it in this.
That was the point in Carrillo, right?
Yeah, that essentially the mortal terror would not, that is, I would argue,
Because I
crucial
think some
here.
of the earlier law before Carrillo was, that every overdose could lead to manslaughter, and we said no.
Yeah, so I think that, to the extent that of not creating any bright line rule of manslaughter, I think that we can avoid that here. I think also that, as in Carter, one of the questions was, where can this end? In this case, you have a fairly limited set of potential players in most of the, certainly in every cab driver robbery, that the number of people who could end up dead by anybody's hand. Obviously, if you had a situation where you had an armed robbery in a public park, you could have, but I mean, essentially trying to get at the number of foreseeable victims that you would meet the standard for involuntary manslaughter for, should something happen under a tight nexus of causation and foreseeability. It's not a parade of horribles, essentially.
It might not even every robbery of a taxi cab driver, maybe not even this one.
Well,
Here you have a knife being stuck in his side, maybe even puncturing, and somebody yelling about killing. So this is not your
No.
typical taxi cab robbery.
Yeah, so certainly,
But even this might not be enough. I don't know. The doctrine
yeah.
needs specificity.
Well, I mean,
Needs
so,
application.
well, first of all, I certainly would submit we're arguing that this was, but I think that, the general sort of, you decide the cases on the easy facts, and you go from, you carve out the doctrine from that. You can't you can say, as in Tejeda, sort of, we see this, but not that. But, and that's not necessarily the end of the story, but I mean, to sort of specifically be like this scenario exactly, but not that scenario, that's deciding a series of cases and seeing how they come out on their facts. And that's the game, so to speak.
Is your view that Tejeda is sort of a subsequent commentary by Chief Justice Gantz on Brown? I'm trying to get a sense, are we supposed to read these as interrelated? Okay, so in Brown, we've gotten rid of felony murder absent malice, and then here he's bringing back this concept for involuntary. I just don't know how we make sense of all that. Yeah.
Well, I read them both as being cases of Chief Justice Gantz throwing out the possibility of manslaughter as a substitute for the murder that people aren't going to get. But that's not, Brown by itself, I would agree. Tejeda is the one that does the work here. I think.
And I haven't reread Brown in a while. Brown does not deal with involuntary manslaughter at all.
No,
So
but it
Brown-
does say that, involuntary manslaughter could be obtained in scenarios where once it could have been a felony murder under the right facts. So it sort of reminds people that there are other sorts of homicide that don't have the concerns in Tejeda, in Brown, that Gantz is putting out. I mean, I think that that's one. When I say also it's sort of a working dicta in Tejeda, that when you look at all of the reasons in Tejeda for not expanding felony murder, they do not implicate involuntary manslaughter. The reasons why the court says, you know, this is a weird doctrine and we don't want to expand it are not at issue here, as I lay out in my brief. Essentially it avoids the harms that have been recently put forward associated with felony murder or its expansion in terms of the.
If you were going to articulate, you know, a rule sort of following up on Justice Gaziano's point, that if you were going to create a rule that allows some of these to go forward, but not all of them, how would you have a way of beginning that discussion for us?
I would say that as in this case where you put a robbery victim in real mortal fear in a way that your actions, a reasonable person would say, are very deliberately cultivating,
If you cut them, I mean, if you have a knife and you cut them, I'm just trying to get a sense of what we're talking about here. Because the heroin case was complicated. This sounds like it could be even worse if we create a middle ground.
This only applies when a bystander or a Confederate are killed, correct?
yes. I mean, I presumably it could also be involuntary manslaughter if you kill the victim, but there's probably other facts in play there.
Well, it could be on the
Yeah.
Brown, it could be involuntary
But more
manslaughter.
traditionally, the interesting part of this discussion, I think, is,
The interesting and complicated part of this discussion leads to the question, how's the defendant supposed to be on notice he can be convicted of involuntary manslaughter?
well, I mean, again, it's that, you know, the fact that wanton and reckless conduct, well, several things. One, the fact that wanton and reckless conduct can foreseeably causing a death can lead you to criminal prosecution, not new at all. The question of how that plays with Tejeda, I mean, I think that in order to have fairness of notice, the fact that you might get charged with something, according to a very recent SJC decision written by the Chief Justice, would put the hypothetical defendant reading all of this law on notice that you're not going to be like, well, maybe I'll get away with it because of this 1863 case. With regard to subjective notice, there was a mention by one of the officers who testified at the grand jury that they thought that when the defendant heard he was charged with the armed assault to rob, he seemed to have been worried he was going to be charged with something else as well. Sort of, they seemed to feel that he was worried he would be responsible for the homicide. So, I mean, it may have crossed his mind in that sense, in addition to the reasonable person standard. Obviously, I think this is an important discussion, even if you decide the defendant did not have notice, the greater principle controls. And just to return briefly to Justice Kafker's question again, I think that, armed robbery involves putting somebody in fear, but even fear of death and plausible fear of death. You know, the fact that also that they're yelling at each other to kill him, not just sort of for his benefit necessarily, that they're creating a very real scenario that they might actually do this and aren't just trying to get his money.
Meaning one of them saying to the other, kill him, basically.
Yeah. I mean, and they're not even saying to him, we're going to kill you, which could have, I mean, again, I think once you bring actual death into it, might be a place at which you've upped the ante to the extent that that person, unless they really know that you're not serious for other reasons of personal relationship or whatever, they could do anything. You put them essentially in fight or flight.
Although a lot of robberies begin with, I'm going to shoot you unless you give me your money, right?
Yeah, well, I mean, that's already, yes, but I mean, you could just say, give me your money, and you're implying you're going to shoot them. But if you need to draw a line within this already very dangerous conduct so as to ensure that it is not so dangerous that everybody is committed. I mean, again, somebody has to die for this to be an involuntary manslaughter charge. Many, many incredibly dangerous scenarios do not kill anybody, thankfully. So, if there are no further questions, Commonwealth rests on its brief.